Hello, my name is Michael Tesoro, and I prepared this presentation entitled Showing Up Restraints, Two Recent Cases on Restraints of Trade. And the reason I've called it that is because I think there's a view that employee restraints of trade are fairly easily enforced and worthwhile things to seek to obtain when you sell a business or when an employee leaves. But in reality, the court looks down on these very unfavourably, and often they're not enforced. And I think these two recent cases just show up the view of the courts towards these employee restraints. Also, there's a bit of moves afoot overseas in the US to ban these types of restraints, and I guess the question is whether the Australian government seeks to follow suit in that approach. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice, Tesoro Legal Consulting, for the last 15 years, and I help companies with competition and consumer law matters. I also do some consultancy work for some legal publishers on competition and consumer law, namely CCH, Wolters Kluwer, LexisNexis. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. The outline of the presentation, I'll talk about two specific cases, the Avant Group and Kittle case, which is a federal court case, and KPW Law and Patel, which is a New South Wales Supreme Court case in the Equity Division. I'll outline the law in relation to restraints as set out in those two cases, then look at the decision in Kittle, the decision in Patel, then look at the moves afoot in the US Federal Trade Commission and in the ACCC, and then finish with some commentary. Now, the law regarding restraints is set out in the Avant case, and the first issue to realise is that a post-termination restraint of an employee is considered prima facie invalid at common law. So you're starting from a position or a presumption that such restraints on employees are invalid, illegal, and it's up to the employer to demonstrate that the restraint was reasonable at the time it was entered into. The Just Group case, which is cited in Avant, spells out the same rules as well. It says there in paragraph 30 that a term of a contract which is a restraint of trade is void as contrary to public policy. So it's seen to be against the public policy of allowing employees and to move around and get different jobs with different employers. And the presumption of it being void can be rebutted by the employer if they can demonstrate two things. Firstly, that the restraint is reasonable as between the parties, but also that it is not unreasonable in the public interest, so it doesn't offend broader public interest issues. It's also noted in Avant that restraints in employment contracts are viewed more strictly and less favourably than other types of restraints in commercial agreements. So the court has a very negative view of employment restraints and will need very strong reasons to find them enforceable. And then in the Just Group case, it says there that a court takes a stricter view of restraint clauses in employment contracts compared to commercial agreements, such as where a person has purchased a business, acquired the goodwill, seeking to run that business. And the public policy issue that's relevant in employee agreements and restraints is that an employer is not simply able to use a restraint to protect themselves from competition from a former employee. There's also noted in Avant that non-solicitation covenants are generally able to be enforced. So if an employer has a term of the employment contract saying that the former employee can't solicit customers of the business, then that's considered something that's enforceable because it's protecting the employer's confidential information. Also, the timing of when things are considered is important. So a restraint will be construed for its real meaning in accordance with the accepted rules of contractual interpretation at the time the restraint was entered into, and then subsequently the court will consider whether the clause is reasonably necessary to protect the employer's legitimate interests. So there's sort of a two-step process. You look at whether restraint is valid and enforceable, and that's at the time it was entered into, and then you look later on when the clause is seeking to be enforced, whether it's reasonably necessary to protect the employer's legitimate interests. And I guess there's also acknowledgement that there are competing values and principles in these type of cases. Obviously, the employer wants to protect their confidential information. The employee wants to be able to get a new job and to work in their chosen profession. So these principles are pulling in different directions, and it's up to the court to reconcile them appropriately. Now, the court in Avant noted that where the drafting of restraint is not clear, vague, then it will apply a very narrow interpretation in favour of the employee. So I think that's important, that this just reflects how courts look negatively at employee restraints, and that where there's any area of doubt, vagueness, the term will be interpreted in a way that's most favourable to the employee. Also, courts will not rewrite a restraint that's poorly drafted. They won't be assisting the employer to achieve their end. And there's this sort of classic quote in this particular second paragraph there: the common law does not encourage the vice of employers terrorising foreign employees with extravagant restraints and the expense of litigation. And then the final sentence there: an employer should not achieve by terror what it cannot have by law. So I think it really reflects the negative approach that courts take under the common law towards employee restraints. They just don't like them and won't enforce them in most cases. Another important issue is that a court may enforce a part of restraint even if the whole restraint exceeds what is reasonable. But for that to occur, the valid restraint has to be clearly severable. So what you see often in order to achieve this outcome is what they call cascading restraints. So separate lines that have different restraints of broader geographic coverage and broader temporal restriction, on the basis that a number of the broader type of restraints may be found to be void and unenforceable, but one of the narrow ones may be upheld. So you see a practice in drafting restraint clauses that they cascade from the broadest or the longest period of time to the narrowest and shortest period of time. Now, there's a bit of law in Patel, and that was really about the way in order to establish grounds for an interlocutory injunction. And there's a two-step test. You have to firstly show that there's a serious question to be tried, and that's on a prima facie basis. And secondly, you have to prove that the balance of convenience favours the granting of the injunction. And in these employee restraint type cases, there's a three-stage process. You've got to firstly assess whether there's a valid contractual restraint, then establish that there is either a breach or an apprehended breach of a valid contractual restraint, and then finally the court needs to determine as a matter of discretion whether to grant relief on the balance of convenience. And the onus of proof is clearly on the plaintiff or the employer to establish that the restraint goes no further than is reasonably necessary to protect the legitimate interests. And the validity of the reasonableness is determined at the time that the restraint is entered into. So you're looking at the date when the employment contract was signed that contains the restraint. But then when exercising discretion on the balance of convenience whether to grant relief, then the court considers matters at the date of the hearing. So there's sort of two dates at which the court will look at the restraint and whether to enforce the restraint. And the final point, which I think is implicit in what's been said before, a legitimate interest of an employer may be to protect their goodwill, customer connections, confidential information, but it's against the public interest for an employer to seek to use a restraint to simply prevent competition from a former employee. And this is noted in Patel as well, that the employer gets the benefit of customer connections which the employee forms during the course of their employment. So if they form relationships and connections with customers, those benefits are to the advantage or accrue to the employer, and they're a legitimate, valuable asset that the employer can protect through restraint. Now, the facts in the Avant case are fairly straightforward. The applicant Avant was engaged in this business of providing advice to clients, businesses of various sizes, about various benefits under government schemes, primarily the Commonwealth Export Market Development Grant Scheme. And the defendant Kittle was an employee of Avant who was terminated from her job in September 2022. So Avant claimed that Kittle, after having been terminated, had solicited the plaintiff's clients, Avant's clients, had been using confidential information which he'd retained from her employment, and finally was threatening to induce Avant's clients to breach the terms of the restraint. Now, Kittle admitted that she had solicited some of Avant's clients. She denied using confidential information. And she said that what she'd done was she'd waited 6 months after termination to solicit former clients because she believed 6 months was a reasonable period of restraint, but that over 6 months would be considered unreasonable. So she obviously turned her mind to the restraint, potentially got some legal advice, and adopted a course of only soliciting any clients after the 6 months had expired. Now, this is a restraint in the Avant agreement. It's quite detailed. As you can see, it covers a wide range of issues that Kittle was not permitted to prepare to be or be involved in any competing business, was not able to canvass, solicit, induce or encourage any person to go with their business, canvass, solicit, approach or accept any approach from any person who was at any time an existing or prospective client of the customer or customer of Avant, interfere in any way with the relationship between Avant and its employees, clients and customers, and act in a restricted way as defined above. So when you go through all those particular terms, you realise that it's actually quite broad, particularly if you realise that Avant and is part of a group of companies. So a group of companies that are engaged in different types of business. So it is quite broad in the way it operates. And as I mentioned earlier, there's often cascading restraints. So here you can see it's a sort of strange cascade because it actually starts at 10 kilometres, goes to 50 kilometres, 200 kilometres, and then goes back to a narrower area, which is the area in which Avant is located. Usually it's the other way around. Usually starts at 200, 50, 10, and then the area the business is located. So this is a bit strangely drafted, but as you can see, the view is that if 200 is considered too broad, maybe 50 will be considered enforceable. If not, maybe 10, and at the narrowest, just the area the business is located. And this is obviously to get around the issue of if any are unenforceable and void, that they'll be severed and a valid clause will be upheld. Then you have a restraint period. And again, it goes from the broadest, this is more the way these things are drafted, 18, 12, 9, 6 and 3. So I guess the court might consider 18, 12 and 9 to be too long. 6 is what the Miss Kittle thought was appropriate, so the court might find 6 months to be a valid and enforceable restraint. There was also this other prospective client, a customer prohibition, and it said that it means a person, entity or company with whom Avant has engaged in negotiations to do business during, and they've got a series of cascading restrictions. But again, it's very broad because it's talking about anybody they've engaged in negotiations with. There's no temporal limit there in terms of 24 months, 18, 12 and 6. So it's effectively saying that anybody they've spoken to over those particular periods will be off limits to Miss Kittle. Now, the decision of the judge, firstly, the judge determined that there was a prima facie case of potential crossover clients between Avant and the defendant, and as such, Avant had got over the first threshold of establishing a serious question. And he was satisfied also that there was a serious question to be tried, that a period of 18 months may be a reasonable period of restraint given the cyclical nature of the plaintiff's business. And what that's a reference to is that the Commonwealth Government will open the period of time for companies to submit applications under the various grant schemes, and then that period will close and they'll be assessed, and then the government will announce its decisions on who gets grants. So because it was a cyclical sort of business, 18 months may be appropriate. In another business that wasn't cyclical in this nature, a shorter period may be seen to be reasonable. However, on the issue of whether to grant the injunction, the judge decided that he wasn't satisfied there was a sufficiently strong case to justify the interlocutory injunction. There were two reasons. When he looked in detail at the specific clauses, so of the view that they were too broad. So one of the clauses referred to existing clients and then prospective client or customer, and the scope of these provisions was so broad it appeared to be almost unlimited and would likely extend to any and all previous clients of any type back to the time when the plaintiff incorporated its business in 2013, which was well before Miss Kittle started to work for the company. So the judge thought that was much too broad a prohibition, and as such would not enforce the restraint. In effect, enforcing the restraint on an interlocutory basis would cause a significant amount of prejudice to Miss Kittle, which probably was unlikely to be upheld at final hearing. The second concern also related to the breadth of the restraint, and this was a reference to competition with the plaintiff's business or the business of any other related corporate of Avant. And the problem here was Avant was involved in a number of different businesses, and a restraint prevented Kittle from working from any competing business of any entity in the Avant group. And obvious problem there was that the other companies in the Avant group were engaged in different types of business, and Ms. Kittle had never worked in those particular industries or sectors. So enforcing the restraint would have prevented her from working in competing businesses that she had never previously worked in the Avant group. So I guess the judge again thought that it was too broad to enforce it on an interlocutory basis. One thing I probably should have mentioned about the Avant case as well is that Miss Kittle offered an undertaking not to engage in particular conduct, and that's a significant reason why the judge did not find the balance of convenience in favour of Avant, because she was voluntarily restricting her conduct and gave undertakings to the court. And moving to the Patel case is particularly interesting to lawyers because what it involves is a restraint on a lawyer from being able to open his own practice. So the facts are that a company called KPW, which is an incorporated legal practice down in Albury-Wodonga, which provided legal services in a range of areas in New South Wales, Victoria and the ACT. And the relevant services in this particular case were criminal law services. And the defendant was Mr. Patel, who was the solicitor who was employed by KPW providing criminal law services, and he was only employed for a relatively short period of time from 2021 to 2023 in the Albury and Wodonga offices. And he had sought to negotiate a bigger interest in KPW, which was not accepted, and as a result he resigned and set up his own business under the name CP Law in Wodonga. And when he quit his job, he received a letter from KPW advising them that they would enforce the restraint. So he was given notice of their intention to pursue the restraint restriction. And then on 22nd May 2023, KPW commenced the proceedings to enforce a restraint in clause 7.3 of his employment contract, and they also sought an interlocutory injunction to stop him operating as a lawyer until final hearing. Now, the restraint was just one paragraph, and I'll read the whole thing. 7.3d, you must not at any time during the term of this agreement and for a period of 2 years after the termination of employment with the employer establish, purchase or obtain an interest in, either directly or indirectly, any business in relation in any way to the employer within a radius of 50 kilometres without the express written consent of the employer, provided that such consent shall not be unreasonably withheld. So as you can see, it's just a standalone provision without any cascading restraints. So that'll probably stand or fall on its face. And the two key issues there is it's a 2-year restraint for an employee who worked for the business for 3 years. So that might be seen to be too long a period of time. And the radius of 50 kilometres is problematic because KPW had a number of different offices. And so it wasn't clear what it was a radius of 50 kilometres from. Was it the Albury Wodonga office or was it one of the other offices? So that was a vague element of the restraint, which again counted against it being enforced. Now, it is somewhat ironic that lawyers would draft such a poor restraint of trade clause as this. Now, the decision was quite straightforward. The judge concluded that there was a real issue whether the restraint was reasonable, given that it stopped Mr. Patel from providing services to a population of over 100,000 people, only a small fraction of which would have been existing clients of KPW. So saying that he can't really provide any service to anybody in that area when only a small number are actually KPW customers seemed not reasonably necessary to protect the legitimate interests of KPW. Furthermore, the view the judge took of clause 7.3 was that it went beyond the protection of KPW's goodwill, and that's the only basis on which it would be found to be enforceable. Rather, to the judge, it appeared to be an attempt to protect KPW from competition for Mr. Patel. Now, there was a view by the judge that the period of restraint of 2 years was too long to protect KPW's goodwill, and that a period of only 6 months may be sufficient to protect KPW in terms of finding a new criminal lawyer to replace Mr. Patel. So there's a hint there that the judge is likely to find a restraint of 6 months as being sufficient. The problem there is it's a standalone quote and doesn't appear to me to be severable. So in order to find a 6-month restraint, the court will have to effectively rewrite the restraint clause to substitute 6 months for 2 years. And as was pointed out in the case law earlier, the courts won't generally rewrite a poorly drafted restraint. Second thing is at final hearing there'll be an issue as to whether clause 7.3d is unreasonable in the public interest. And this was based on evidence put forward by Mr. Patel that there was a shortage of criminal defence lawyers in this particular area. Relevantly, one of the major criminal lawyers in this area had been made a judicial registrar, so the number of lawyers specialising in criminal law had reduced, and as a result there were concerns by legal aid that there wouldn't be sufficient number of criminal defence lawyers to represent people in the area who needed legal representation. So if restraint is actually going to have a negative impact on the public by preventing individuals from being able to obtain criminal defence representation, then that'll definitely count against enforcing the restraint. So on the balance of convenience, the judge noted all the issues that had to be balanced up. So as you can see, the first issue in granting injunction is whether damages would be an adequate remedy, the defendant, Mr. Patel's right to livelihood, whether KPW had delayed in taking the case, the impact on third parties. So relevantly here it'd be on individuals charged with criminal offences who needed representation, whether KPW warned Mr. Patel and that he went into the situation with eyes wide open, which is probably true. He was warned by KPW that they would enforce the restraint. Whether any hardship that would be visited on Mr. Patel has come about due to his own actions, whether he was the author of his own misfortune. The strength of the case, which I think you can see the judge is suggesting it's not a very strong case, and finally some undertakings and whether they've been given by Patel to the court, which did occur in this case. Some undertakings were offered to the court. So what the judge indicated at the interlocutory level was that there was a risk that if Mr. Patel was restrained by an interlocutory injunction, individuals would be unable to find a replacement criminal lawyer of equal standing, because Mr. Patel was a very experienced criminal lawyer, to represent them in matters that were already before the courts. So that would create a significant public detriment, which weighed against the granting of the interlocutory injunction. And this was all backed up by evidence in Mr. Patel's affidavit that it would be hard to find a replacement lawyer for these particular clients. Now, the judge gave KPW a pretty strong hint that they were probably going to lose at final hearing. He said that the strength of the case, KPW's case, was low. He didn't think it was a strong case because 7.3D was poorly drafted. There was a lot of uncertainty as to its meaning, and it seemed to him that there was an attempt to protect KPW from competition and not so much seeking to protect its goodwill. I think also the fact that it was a standalone quote without any cascading provisions means that the only way it could be found to be enforceable is if the court rewrote it, which, as I said earlier, is something courts don't want to do. And if that's the case, 2 years is too long, 50-kilometre radius is too vague. I think the whole restraint would be found to be unenforceable. So the decision on the balance of convenience was that it wouldn't grant the injunctions. A significant factor here again was the undertaking provided by Mr. Patel, and he makes the point again that it seems to him that the restraint is really all about preventing legitimate competition from Mr. Patel to KPW, and that is clearly inconsistent with the policy of the relevant legislation, but also the common law. So the decision was, when all the factors were weighed up, he concluded that the prejudice suffered by KPW was outweighed by the prejudice that would be suffered by Mr. Patel if an interlocutory injunction was granted. Now, the interesting thing in the US, the Federal Trade Commission, which is a bit like the ACCC in terms of its jurisdiction over consumer law matters, has proposed a rule which will outlaw the use of employee restraints across the US. And this is being proposed under Sections 5 and 6G of the Federal Trade Commission Act, which prevents unfair methods of competition. And so the US Federal Trade Commission has come to the view that the use of employee restraints, particularly in the franchise sector, are an unfair method of competition and should be banned, that they're effectively having a very negative impact on employees, but particularly used in relation to jobs which are not highly paid jobs, lower food service type jobs, lower paid jobs, and people are being prevented from working in those industries by these restraints. So as you can see there, the Commission is concerned to ensure that competition policy is aligned with the current economic evidence about the consequences of non-compete clauses. There is a strong view that FTC has that these non-compete clauses, which really came into vogue many decades ago, allow serious anti-competitive harm to labour markets, product markets and service markets. So they're having a very profound anti-competitive effect. And this might be the case that somebody works for a fast food outlet in a small town and their employment contract says that they can't work for another fast food outlet within a particular radius. So effectively somebody who's flipping burgers at McDonald's may not be prevented to get a job working down the road for Hungry Jack's doing the same job. So as you can see, the use of these and the enforcement of these in relation to lower paid jobs is a serious concern. And as you can see there, the scope of the rule is fairly broad. So as you can see, the proposed rule would define the term non-compete clause as a contractual term between an employer and a worker that prevents a worker from seeking or accepting employment with another person, but also operating a business after the conclusion of the worker's employment with the employer. So it's actually going beyond just employment relations to actually setting up a competing business. The proposed rule would also clarify that whether a contractual provision is a non-compete clause would depend not on what the provision is called, but how it functions. So obviously the FTC would be seeking to look at the substance of the term, not the fact that it was described as a non-compete clause or something of that nature. So probably as a response to the FTC's moves in the US, which that rule has not been introduced yet, it's currently open for comment. But I think it's a strong probability that once the comment period ends, the FTC is going to go ahead and propose the rule and it'll be accepted. I don't know quite the process, whether the Biden administration has to accept it or not, but I think the rule will probably come into effect. Can't see very much stopping that from occurring. So in Australia, what happened, the Assistant Treasurer, Andrew Lee, formally requested the ACCC to look into this issue, look into the competitive impacts of non-compete restraints and whether the Australian government should take any action in response. And I couldn't actually find any formal request. So the source for this particular information is a very good article by Herbert Smith Freehills that I've referenced there, which talks about this formal referral. And clearly the ACCC has to look into the prevalence of these type of agreements. I think they're quite prevalent in the market and their impacts on competition. And I think the difference maybe in Australia to the US is that courts, as I have indicated in this talk, are very reluctant to enforce these particular terms. There's a real presumption of the common law against enforceability. So the competitive impact of these types of agreements is probably less in Australia than the US and probably less prevalent in these lower paid jobs than maybe in the US. But the ACCC is required to investigate the issue and report to government. And I guess it's possible that the government may consider going down the same path as the US Federal Trade Commission and imposing a ban. Clearly the big factor there will be whether the FTC's rule comes into effect. If that happens, I think the Australian government will seriously look at some way of imposing a similar ban in Australia. So just a bit of commentary. I think it's quite apparent from the cases that injunctions and restraint of trade clauses in the employment area are very unlikely to be granted because there's a lot of detriment that may be caused, and often restraint trade clauses are poorly drafted, so they're unlikely to be upheld at the final hearing. There's a presumption that employment restraints are void under common law, so it's important for lawyers to be aware of that if they're spending their clients' money in drafting up various restraint clauses. Realistically, the courts are reluctant to enforce these clauses in many instances. They're very poorly drafted. Clearly having a cascading set of restraints is a good approach to take. If you've just got one standalone term, the court won't rewrite it, and various clauses that might be too broad won't be severed. They're not severable. Clearly it's important to have cascading restraints, but also to define your terms well and clearly so there's absolutely no vagueness of the scope. You've got to make sure the terms, the restraints aren't too broad, that they don't take in additional businesses or additional areas that they shouldn't. And there has to be some relationship, I think, between the period of employment and the restraint. If you're seeking to restrain somebody for 2 years after working for you for 3 years, it's going to be problematic. So often restraints are too broad and very vague. You can't use restraints simply to prevent competition. I think that's the key thing. They've got to be aimed at preventing a loss of goodwill. And really, if you're focusing on non-solicitation and use of confidential information, they're likely to be held enforceable. But just a blanket ban on somebody setting up a competing business or working for a competing business is not going to be held to be enforceable and contrary to public policy. Big question of whether the FTC rule will come into effect. I suspect it will. Can't see there being any way that the FTC is not going to press ahead with that rule, and if there needs to be some sort of Biden administration approval, I think they'll get that. The big question is, what will the Australian government and the ACCC do? It'll be interesting to see if the ACCC report is made public and we can see what they found, and whether the Australian government is keen to ban these type of agreements across the industry. It'll be a big step, but I don't think it's beyond the realms of possibility that it may come in. So that's all I had. Hopefully that's been helpful, just to shed a bit of light on employee restraints of trade and current developments in that particular area. If you have any questions about this presentation, feel free to give me a call or send me an email. Bye-bye.